Hello. All right. Welcome. Welcome back. So, colleagues, I'll suggest that we move to the next session while I try to get hold of the government. They were supposed to be here by now. We just cannot keep on waiting because we have sessions to cover. Yes. But let's not conclude. Let's wait. I'm always a hopeful one. Oh yeah, maybe. That's being very nice. All right. And it's raining. All right. So colleagues, I will suggest that we move to the next session, which will be led by my colleague Francis. So I will allow Francis to introduce himself, then he's going to lead with a presentation. Francis, over to you.
Yeah, thank you very much, Jane. Yeah, dear colleagues, when you have last presentation like this, it's always people are tired and everybody just want to go. But yeah, I assure you, I won't take much of your time. So like I said earlier, my name is Francis Igiriog. So I'm the Anti-Racial Discrimination Advisor for the United Nations Office of the High Commissioner for Human Rights, the regional office for Southern Africa. So like my colleague said, we cover 14 countries within the region. And as you can see, the presentation is on the International Convention on the Elimination of All Forms of Racial Discrimination, which we call acronym ICID. So essentially, the terms you'll be hearing, you hear me, if I mention ICID, it means I'm referring to that treaty, an international convention on the elimination of all forms of racial discrimination. You will also hear me mention SAD. If I mention SAD, I'm talking about the treaty body, like the Committee on Elimination of Racial Discrimination, that is SAD. Yeah. So before we proceed, let me know among us here, who among you at least is conversant with this treaty? Who among you has read some of the provisions or has seen the provisions of ICID before? So because from our experience, we discovered that most civil society organizations, they know more about ICCPR, they know more about the economic social cultural right, they know more about Convention on the Right of the Child and others, but for ICID, for maybe, I don't know the reason why people are not conversant with it. And that's why we are here to let you know what are the provisions and why is it necessary. Because as members of the civil society organization, one of the things you do is to help in monitoring implementations of this treaty. It is part of the duty is to say that the government of Namibia, who is also a state party to this treaty, implements what it undertakes to implement. So it's very, very important because Namibia was reviewed, SAD reviewed Namibia 2 years ago. So a couple of years again, Namibia will still go through the process of review. And it is also expected that some of you that work on this area can also present shadow reports, because the committee rely very much on information from civil society when reviewing state parties in some of this treaty. So as you can see, the International Convention on the Elimination of All Forms of Racial Discrimination was adopted by the General Assembly in 1965 and entered into force in 1969. In effect, this year we are celebrating the 60 years anniversary of ISAD. This year there will be a series of activities we call ISAD at 60 to commemorate the adoption, 60 years adoption of this. And its objective essentially is to prevent and eliminate all forms of racial discrimination and to promote racial equality. As of date, 182 state parties. We have 182 state parties to the treaty. In other words, 182 countries have either ratified or acceded to the treaty. And Namibia is one of them. Namibia acceded to the treaty on 11 November 1982. So the treaty has 25 articles divided into three parts. 25 articles. The articles are not many. But for purpose of this session, our focus will be on the first part, which is the substantive provision of that treaty. That's Articles 1 to 7. That is what we'll be looking at. The second part deals with SAD itself, the treaty body. We will look at the treaty body after the present presentation. Then also, one of the things we'll also be hearing is general recommendations. General recommendations. When we talk about general recommendations, we are talking about the expert interpretation of the treaty by members of the treaty bodies. Remember what I said, that SAD is the treaty body that is responsible for monitoring ISAD. In other words, when countries submit their report, they submit to SAD, who had the duty to review. So one of their function is to give authoritative interpretation of each section of this treaty to guide states to understand what actually these provisions are talking about. Otherwise, there will be some misinterpretation and erroneous interpretation. So we just go straight to Article 1, Sub 1, which defines racial discrimination. So as you can see, it defines racial discrimination as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. Essentially, that long grammar, what is essentially talking about is it defined racial discrimination as any discrimination, and by discrimination is referring to distinction, exclusion, restriction, or preference. In other words, any distinction, any discrimination based on race. This is very important. Based on race, color, descent, or national or ethnic origin. So any discrimination that is based on these grounds, that is what falls under ISAD. So discrimination must be based on race, color, descent, ethnic, or national origin. And this is the minimum requirement. Countries are also free to put other issues like age, sexual orientation, and all those. But this minimum ground, if you omit any one, then it means that law or policy is not in compliance with international human rights standard. In fact, one of the things that the committee complained last time when they reviewed Namibia was that the Racial Discrimination Prohibition Act of Namibia. Who among you know about that act? The Racial Discrimination Prohibition Act is an act, a Namibian act. So one of the things that the committee complained about is that that act does not comply to international human rights standard, because among the grounds it listed there, issue of descent, the ground of descent is not there. But the issue of race, color, ethnic and national origin are covered, but descent is not covered. So one of the concerns raised by the committee that Namibia should try to amend that particular act to include that particular ground so that every sort of person will be covered in terms of prohibiting racial discrimination. So you can see the division set out 5 grounds: race, color, descent, and national and ethnic origin. Like I said, any law or policy that does not include all these grounds will be seen as not compared to international human rights standard. And it's clear there is no hierarchy among these 5 categories. In other words, no one is more important than the other. Everyone must be protected accordingly, like any other one. So then, regarding the question of who belongs to which group, it is the opinion of SAD. This area, essentially, there is, especially within the region, there's always this challenge of indigenous groups, states saying that indigenous groups and that there are no indigenous groups in their country, that everyone is indigenous. So what SAD is saying is, it is for the group to identify themselves to which group they belong. It is not for anybody. It is not for the state to say, okay, you belong to this group or you don't belong, unless there is a justifiable reason. So he's saying, regarding the question of who belongs to which group, it is the opinion of SAD that identification of individual as being members of a particular racial or ethnic group shall, if no justification exists to the contrary, be based upon self-identification by the individuals concerned. Unless there is justifiable reason, it is for that group, for the person concerned to say, okay, look, I belong to this group, I don't belong. It is by self-identification. That is very, very important. Then SAD also identified that there are some particular groups of individuals who are more vulnerable in issues of racial discrimination. And these are minority groups, which can be ethnic, national, or at least linguistic minority groups, indigenous groups, migrants, refugees, and asylum seekers. So they make it clear that these groups are groups that are prone most often to racial discrimination. Then, still talking about that Article 1.1, then the committee also disagrees between discrimination based on descent and that of race. So in 2002, the SAD issued their recommendation number 29, stating that the term descent does not solely refer to race and has a meaning and application which complements the other prohibited ground. In other words, that discrimination based on that descent, the ground of descent is different from that of race. How is it different? It states that discrimination based on descent includes discrimination against members of communities based on forms of social stratification, such as caste and the analogous systems of inherited status, which nullify or impair their enjoyment of rights. Such discrimination may involve the following factors. Remember, we're talking about discrimination based on descent. It's an inability or restricted ability to alter inherited status. Any group of persons that do not have the ability to change their status, of course, status which is not positive, which is not good for a human being. But they are not able to change their status because of their social status. Then, in such situation, any discrimination based on them will be looked at based on descent. Socially enforced restriction on marriage outside the community. If such group have challenge of marrying outside their community, if there is discrimination that people don't marry them because of their status, and they don't marry outside, only among themselves. It's not that it is what they chose to do, but because of their social status, they are discriminated against in that way. No one will marry them, and they will not marry an outside apart from among themselves. So in such situation, SAD is looking at it that it is a discrimination based on descent. Then you have private and public segregation in housing and education, access to public places, places of worship, and public sources of food and water. Limitation of freedom to renounce inherited occupations or degrading or hazardous work. Subjection to debt bondage, among others. So any group that faces this type of discrimination, essentially, SAD is looking at it, and it is a discrimination based on descent. Again, if you look at that definition of racial discrimination in that Article 1, you will see it says discrimination based on one's race, color, descent, national or ethnic origin, which has the purpose or effect. It means that discrimination can be deliberate. If it has the purpose, it means that discrimination is deliberate. The person deliberately discriminates against this person for the purpose of denying their right or affecting their right. It's also saying that such discrimination can have the effect. In other words, not a purpose, which means that it is not deliberate, but the effect of the discrimination still impairs the enjoyment of that right. So whether it is deliberate or not, as long as it has the effect of impairing the enjoyment of right of such people, it is still racial discrimination. So that's why in General Recommendation number 14, SAD stated that a distinction is contrary to the Convention if it has either the purpose or the effect of impairing particular rights and freedom. This is confirmed by the obligation placed on state parties by Article 2 to nullify any law or practice which has the effect of creating or perpetuating racial discrimination. So one of the obligations the state has is to ensure that any law or policy which has the effect of perpetuating racial discrimination, even though it is not deliberate, but as long as it has the effect of causing such, that the state is under obligation to totally either review or repeal such laws. So in seeking to determine whether an action has an effect contrary to the Convention, it will look to see whether that action has an unjustifiable disparate impact upon a group distinguished by race, color, descent, or national or ethnic origin. Please feel free to ask questions as I'm going because of time. So that Article 1, sub 2 and sub 3 talks about issue of citizens and non-citizens. Because most often, because of this, the way it is coined, this provision, some states feel that they are not under obligation to report about non-citizens under this treaty. Because Section 1.2 said this convention shall not apply to distinctions, exclusions, restrictions, or preference made by a state party to this convention between citizens and non-citizens. Then 3 said, nothing in this convention may be interpreted as affecting in any way the legal provisions of state parties concerning nationality, citizenship, or naturalization, provided that such provisions do not discriminate against any particular nationality. So with this provision, many states feel that it excludes them from giving account of non-citizens in their state. But SAD say that such interpretation is wrong. They now state that state interpret Article 1 as absolving them from any obligation to report about electing legislation on foreigners. This prompted SAD to issue General Recommendation Number 11. You remember what I said about General Recommendation? This is an expert interpretation given by members of the treaty body to the treaty itself. So they issued General Recommendation Number 11 in 1993 to the effect that the convention is generally applicable to discrimination against immigrants or foreigners. In other words, not only to citizens. This interpretation was developed as a consequence of the practice in many countries where distinctions between citizens and non-citizens appear to follow ethnic patterns and are inherently discriminatory in their effect. So the same Article 2 talking about the issue of xenophobic, discriminatory, and racist practices against non-citizens, including migrants, refugees, asylum seekers, and undocumented non-citizens, and persons who cannot establish the national of the state or whose territory they live. SAD issued its General Recommendation Number 30 in 2004. And it is to clarify that the state parties various responsibility with regard to non-citizens and make clear that Article 1(2) should not be interpreted as reducing the rights and freedoms for everyone, especially the rights that already established in other human rights treaties, both UDHR and ICCPR and other human rights, that no state should reduce the rights of individuals because of the way they interpreted this section. So then they stated in that general recommendation that differential treatment based on citizenship or immigration status will constitute discrimination if the criteria for such differentiation, judged in the light of the objective and purpose of the convention, are not applied pursuant to a legitimate aim and are not proportional to the achievement. So, in other words, all the provisions is saying that states should be responsible and ensure that citizens are not citizens within their domain and not discriminated against based on this. Then Article 1(4) talk about special measures. Special measures. So what this article is essentially talking about is that the states should make provision for special measures in such a way that those vulnerable groups who are marginalized can have, the state can develop some programs in terms of law or policy so that those people will have opportunity to live a good life like others. And of course, many countries have special measures. You can call it affirmative action. Some call it positive measures. In Namibia, you guys have a Affirmative Action Employment Act. How many of you are aware of it? Yeah. So that law is an affirmative action act. The whole idea is to bring those who are vulnerable, who are not at par with others, to be able to have opportunity, to have employment, and also be like others. So he said these measures are considered legitimate on the condition that such measures do not lead to maintenance of separate rights for different groups, and that they shall cease after the objective for which they were taken have been achieved. It is important that states distinguish these special measures from unjustifiable preferences. This is important. And should be noted that to treat in an equal manner persons or groups whose situations are objectively different will constitute discrimination in effect. As with the unequal treatment of persons whose situations are objectively the same. In other words, what he's saying that for you to treat in an equal manner persons or groups whose situations are objectively different will constitute discrimination. Similarly, it will also contribute discrimination if you treat unequal persons whose situation are objectively the same differently. Then we'll talk about multiple discrimination. Multiple discrimination, of course, issue of intersectionality comes in. So the committee is concerned that in most reports that states bring before them, there is no emphasis on the issue of multiple discrimination, because men and women face discrimination in different degrees. So SAD pays special attention to cases where multiple forms of discrimination are involved. Regarding the intersectionality of gender, in its general recommendation number 25, it noted that racial discrimination does not always affect women and men equally or in the same way. Certain forms of racial discrimination directly affect women, such as sexual violation against women of particular racial or ethnic groups, or coerced sterilization of indigenous women. So SAD now integrates gender perspective into its work, and also recommending that state parties provide disaggregated data with regard to the gender dimensions of racial discrimination, as well as to take necessary actions in this regard. So any report, SAD would like to see the data you have, how disaggregated are they? You don't just lump the same data between men and women. You have to give a separate data between how does it affect women, how does it affect men, how does it affect indigenous groups. And sometimes you see, for instance, a woman, a disabled woman who is from indigenous community, and also a lesbian. So you can see such person face multiple discrimination. So the question SAD asks now is, such person, what measure does the state put in place to protect such person from discrimination? Because you don't just treat the person the same way you treat others, because has peculiar circumstances different from others. This is what they're talking about. Then we'll go on into state obligations. Of course, when states ratify treaties, they incur certain obligations. In other words, what they're supposed to do in order to carry out such treaty. So Article 2 requires the state party to prohibit and stop racial discrimination by any persons, groups, organizations without any distinction between public and private. So such obligation under Article 2.1 include not engage in any act or practice of racial discrimination. In other words, the state itself should not engage in any act or practice of racial discrimination. To ensure that all public authorities and institutions do not engage in any act or practice of racial discrimination. Not to sponsor, defend, or support racial discrimination by any person or organization. To review policies and to amend or repeal any laws and regulations which have the effect of creating or perpetuating racial discrimination. So Article 2.2 talked about special measure in terms of economic, social, and cultural rights. That states should take special measure to ensure that people who are affected by this also have sort of affirmative action in this regard. So Article 3 state continues state obligations. State parties particularly condemn racial segregation and appetite and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction. So initially, when states hear about racial segregation and appetite, the impression they had was it is only for South Africa. When they hear about appetite, but the SAD makes it clear in General Recommendation number 1995 that Article 3 prohibits all forms of racial segregation in all countries, including unintended segregation in housing and or education. I'm coming. States also have the obligation to eradicate the consequences of such practices undertaken or tolerated by previous government. All right. Yes.
Thank you, sir. In the second slide, you showed us that Namibia joined ICERT in 1982. And then I was like, who of Namibia joined in
Ratified.
1982? Because we didn't have a sovereign government at that time. Yeah. Namibia acceded to ICERT on 11 November 1982. I was like, wow. Who acceded? Because Namibia, the term was already there, but we were still under South African mandate. I just wanted to ask, and now that I saw that South Africa, under Article 3, they seem to, state parties particular condemn that South Africa until 1989, they didn't stick to this. Yes, they put in a quasi-government, but it was still controlled by Pretoria. I just wanted to clarify that, who exceeded. And then in the 5 pillars against discrimination, the economic hasn't really been outlined because colonialism and apartheid were actually economic discriminatory system which took land from people and distributed it to minorities. So the economic aspect can't be overemphasized. And reading all this, I'm wondering, and what is happening in Gaza and Israel, in Palestine and Israel today when we read this? Those are the 3 things I wanted to mention. Thank you.
Okay. Yeah, thank you very much. So the first issue you raised there, that the 1982, that Namibia was still under, of course, under the international law system, states, maybe the power that is in control then can take certain decision for the country. Then when you now take over, it is for you. It is for you to either adopt the action that was taken, or reject them, and then take steps for your own. So for this to be there, it means Namibia still maybe confirmed that action. Otherwise, normally, if maybe an occupied power did something, because as far as international law is recognized, as of that time, those are the authority in charge. Sorry, so let's take it easy. Let's take it. Sorry.
In terms of becoming a state party to a treaty, there are 3 ways that you can become a state party to a treaty. The first one is that you can either ratify. You ratify when the treaty has been opened for signature. Once the signature number has been attained, and then when you ratify, you become a state party to the treaty. The next one, you can either accede to the treaty. Accession is when the treaty has already come into force, it has already attained a good number of ratification, then it is in force, then you can accede to the treaty. In the context of Namibia, what applies here, it is the 3rd one, which is called succession. In the context, when I was in South Sudan, I was also leading the work of the government to give them guidance on how to become state party to human rights treaties. When South Sudan separated from the North, the question that we asked the government is that you were part of the government of the North. You were part of Khartoum. It was one country. Do you want to succeed to all the treaties that Sudan was a party to, or do you want to start afresh? The government said, sorry, we want to start afresh. We don't want to automatically succeed to the treaties that Khartoum was a party to. We are going to start our own process afresh. Going back to what my colleague mentioned, when you regain independence or when you gain independence, the government must have been asked, do you want to continue to maintain this status as a party to CERT? If the government did not want to, the government would have said, okay, we are going to start our own process afresh and sign the treaty afresh as a new state. But what the government did was to succeed to the treaties that the previous status quo was a party to. Yes, so which means that Namibia got its independence and succeeded to those treaties. That is why you still see that date, which is before independence. Is that clear now? Yeah, that is, yeah. Thank you so much.
So,
And
I want to say something.
it looks like he was trying to bring in a national context that it is also in your law, it is in your constitution.
Yeah, no, I just wanted to actually add, but you put it very well, because if you look at our constitution, in Article 143 talks about existing international agreements, and therefore when we became independent, we had the choice to continue with what we find, or to start afresh, or to abolish some and keep some. Yeah. And therefore, and it goes further to 144, but mostly 143 is very clear. So this is when we became independent, we repealed a lot of colonial laws as well, and we kept some of them that we are using until today. It's actually the only aspect I wanted to give.
Thank you so much. Let me take to him that I'll come back to you now.
You know what's amazing? South Africa knew 1982 it's wrong, and they still kept it until 1994.
Just to give context to your question, we must remember that Namibia was given to South Africa to administer as a mandate to prepare for independence, right? In 1966, the UN rejected the mandate that South Africa had over Namibia because it extended its territory into Namibia. So the decision was not taken by South Africa. The decision was taken by the UN Council of Namibia, which was established by UNGA, which represented the interest of the Namibian people. And this was a rare case where, which was accepted by the UN Secretary General, because the Council of Namibia, the UN Council of Namibia, was a non-governing body, so this was a very rare case. And because it was in the interest of the Namibian people, when Namibia became independent, they just, continued with it. Yes.
Thank you so much.
That makes more sense.
Thank you. All right. And then it's done. All right. Please go ahead.
Okay. Yeah. So I hope that is clear now. Yeah. So yeah, that's why it's good. It's good to go through some of these treaties that your country has subscribed and see the dates and the history behind them. At least you've learned this one today. Okay. Okay, yeah. The Gaza issue, of course. Not not only Gaza, other countries that also having similar challenges. Of course, the treaty bodies and the UN generally, severally, they've condemned what is going on there. So, but at the end of the day, the Israel will still give account because the signatory to this treaty. So they will also submit their report and also get the feedback and the concerned recommendations. You know, the challenge we have in the international human rights framework, most time people will expect to have a standby army, to have a standby army that will enforce all these things. But it doesn't work that way. It doesn't work like I think Jean also explained. The international human rights framework essentially is dialogue and persuasion, and sometimes, of course, at the rare cases, you can also have issue of, especially countries that rely on aids from bigger countries. Maybe because of your human rights, you can be denied of aid because of your human rights record. But essentially, there is no standby army that will put states in jail for violating some of these things, unfortunately. But the process has been working, and of course, we've seen the gains and the progress we've recorded. So I think John mentioned some of them before. So, and if not the intervention of the international community and also the pressure, it would have been worse as it is. All right. So another question?
Francis, let's proceed because to the surprise of everyone, the government says that they're coming at 16:45.
16?
16:50. So, yeah. So the most important thing is that they're coming.
So Article 4, prohibition of racial incitement. Article 4 made a lot of prohibition, prohibiting racial incitement, so that the state should ensure that all these provisions, of course, you guys will get all this presentation. So all these provision, the dissemination of ideas based upon racial superiority or hatred, incitement to racial discrimination, acts of violence, and others, that the government, the state must prohibit it and criminalize it in its laws. Then Article 5 itself make provision for the list of human rights. It provides a non-executive list of rights and state parties have the obligation to guarantee to everyone, regardless of race, color, national or ethnic origin. So it does not, whether you're a citizen or non-citizen. This Article 5 provides non-executive list of human rights. In other words, these are all the rights that contains in both the Universal Declaration of Human Rights, ICCPR, and the International Covenant on Economic, Social, and Cultural Rights. All those rights is very clear that everybody should enjoy them, and nobody should discriminated against in any of these rights based on your race, color, descent, national or ethnic origin. So yeah, I need to mention like the last paragraph there, you can see in interpreting Article 5, SAD makes a distinction between rights to be enjoyed by all persons living in a given state and rights of its citizens. So while many of the rights and freedoms mentioned in Article 5 fall under the former, in other words, the one that be enjoyed by everybody, the right to participate in elections, to vote, and to stand for election are covered by the letter. In other words, the right to participate in elections, to vote, and to stand for elections are rights of the citizens. So they are very clear on this. Then Article 6 essentially provide for remedies for racial discrimination. Because for every right, there is a remedy. If anyone has any right, then it means there's a remedy. So this article is making it clear that anybody that whose right is violated or who is discriminated against should be entitled to redress. And the redress does not just means maybe imprison the perpetrator or fine, but it encourages the courts to award financial damages to the victims. That is very, very important. Then this is the last article under the substantive section. Is about education. So this article requires states to adopt immediate and effective measures, particularly in the field of teaching, education, and culture, in order to combat prejudice which lead to racial discrimination and to promote understanding, tolerance, and friendship among nations. So, and in terms of education, you're not just talking about formal education. It also emphasizes on the need to educate the law enforcement agencies, like the military, the police, on issues of racial discrimination. This is very, very, very important. Because the last review of Namibia, one of the things that came up was the issue of police profiling. Because the committee frowned on the report, and that report came from the report of the Office of the Ombudsman, that there were a series of reports of police, of racial profiling by the police. Racial profiling by the police, especially on the black population. So the committee frowned on it and called on the government to ensure that the police and other security agencies are enlightened and educated on the provision of this treaty, so that they should know that such act is not acceptable. So, so John, this end of procedure for this substantive section, I should go to the
you can go
to the other one.
if there are no comments or questions. Because
So if there are no comments, we can go to. Yeah, please go ahead.
yeah, there are comments. Please, let me help you. It's fine. You sit. I'll take care of it. Thank you so much for your help.
Yeah, thanks very much for this. Especially when you said, and I'm glad that the approach is like that, that especially that it is for the community to identify themselves. It is not for the state to determine, for example, in the case of indigenous communities. Because we, in our sector, we find it quite challenging, where in Namibia and in Africa in general, people will say we are all indigenous. Who are the indigenous? And that denies us with an opportunity to come up with specific strategic measures to identify and address particular issues that are faced by that given community. So I'm not sure what remedies are there for civil society actors in this case to be able to drive that agenda to say, because I mean it's also in Namibia. I mean, yes, government has recognized certain communities, but there are others that also still claim, no, we are also part of that group. It's not just those groups that have been defined by the state. So how would you advise from other countries how that issue has been approached and been dealt with?
Yeah. Okay. Go ahead.
Thank you. I think it's a very crucial one, that one, because it's one of the areas where the organization that I work for also operates in, and we specifically, I can even talk about direct ones like the traditional communities, for example, with certain tribes finding themselves in certain traditional community with an established traditional authority over having the jurisdiction over that. And then you have this small group which also wants their own recognition because they are of different ethnic, whether it's language and let me just say grounds. But if you look at our Traditional Authorities Act, especially Section 3, it prohibits any establishment of another traditional authority in a jurisdiction where already one, and there are even fines to that, and we are actually stuck on that because it's in a lot of regions now, whether it's in the central and especially north as well, and it's becoming too much now.
Especially the, what do you call it, Odhimba people, they call it nowadays. They are the descendants of the Himbas, but as it says, of Adhembas, they are not recognized by the government for that.
Yeah, I think we have maybe similar cases in other countries, but the issue there is I think these are things that people keep dialoguing with the government on some of these issues, because even the special rapporteur on right of the indigenous people that went to Botswana, I think there are similar reports, similar complaints, by also indigenous community there, So I think the best way to go about such a thing, such complaint, is to because the resident coordinator, I mean the ROC here cannot solve such a problem. I mean the UN here. So the best way to solve it is to get in touch with the special rapporteur on right of indigenous people. That is send communication to him, then stating those ground. So normally what he will now do is to look at the complaint. If he's taking something that he will take forward, then he will communicate to the government the issue of those concerns, and then of course the government will need to respond. If it's something that also they will take forward, he can now appeal to them based on the right of indigenous people, because like that the article said, everybody is entitled to identify him or herself where he belongs. It's not for the government to say that. That is one step. Then another thing again is for the government to now say, okay, now you have identified yourself. Okay, we now open door for you to belong to, maybe if it is maybe the chieftaincy, maybe parliament or law making body. So that's where it becomes tricky, because if it now involves issue of funding support, because the government will always find a way to deny. So but with the intervention of the special rapporteur, of course, he has also done that in other countries, to engage with the government and discuss with them, and also emphasize on the need for such people to have their way on that. And in some places it has been successful. Of course, in some places it's still ongoing discussion. Like what normally is the issue of human rights is not something you just discuss that day and it ends that day. It most often is an ongoing discussion and dialogue. At the end of the day, if it's something that depending on the government and the political will, such people may have their way. But what we are fighting within the region, at least, is for all the countries, at least, to recognize indigenous people within their domain. Because the challenge presently, most countries don't even recognize indigenous groups legally in their law, and that's a big challenge. So we are hoping that, at least with the work the special rapporteur is doing within the region, that some of these things will have improvement as they go by. Another question?
Maybe it's a little bit off. How does one convince government to invite an UN independent expert in difficult context
No,
on that issue?
Yeah, to invite is one thing, But for instance, to send communication, the special rapporteur does not need the consent of government to send communication. For instance, if as a civil society organization, you can send communication to the special rapporteur on your concerns if it's concerning indigenous people. So if you send communication to the special rapporteur, of course there's process to send that communication. So the special rapporteur can, after going through, can also communicate to the government. So he doesn't need the consent of the government to send the communication. It's different from visiting. That's a different altogether.
Invite.
Yeah, then to invite, of course, the government has to give consent for the special rapporteur to come. Some states send give open invite at any time, but Namibia is not one of those. Yeah.
I think for you to try to convince the government to accept the visit, you need to first start by sharing information with the special rapporteur. That is going to help now to ensure that you can advocate from two directions. You cannot expect the special rapporteur to consider your country as a priority for a visit when you are not sharing information on the issue that you want a special rapporteur to work on. And that is in line with what my colleague Francis mentioned. Once a special rapporteur has received information that has triggered several communications with the government, it is going to ring a bell that, okay, listen, this is becoming a very serious issue. I have sent communication. My next step now is that I need to undertake a country visit. So that is one. The next thing is that you also have to engage with the government to try to convince the government to accept the visit. But the third one, which I will advise you to also look at, is to engage with members of the diplomatic corps. Members of the diplomatic corps, they also engage with the government. As I was telling some of the colleagues, like the EU has this dialogue with the government all the time. I think this dialogue takes place around September. If you see that that dialogue is about to happen, you please also engage with them, to also engage with the government to try to put this forward. For example, it took us a while for the government of Botswana to accept a visit of the special rapporteur on indigenous people. And this is the second visit anyway. There was the first one, then the second one. So you just have to be able to explore all these options. And then once that is also taken into consideration, and then they are going to consider the country. However, it is important for you to also know that the special rapporteur can put your country on the timetable for a visit and send a reminder to the government to undertake a visit, but the government is silent on it. But once the government is silent, you should not relent your effort. You should continue to engage with them so that they should please accept that visit. I hope that hope that helps. Yeah. Thank you.
All right, thank you. So, you still have a question?
It was just linked to this question, because in the sense of, and I get what Selen is saying, because we've also engaged government, we've lobbied with government, we've advocated as to why the special rapporteur must come, right? And of course the invitations were sent and they declined. And it has been a struggle to get the special rapporteur here to Namibia. But in such instances, are there mechanisms that we can explore because government is not willing to
So which of the special rapporteur is that?
Soggy.
Oh, sorry.
Yeah. Oh, yeah, and that has been the frustration, because we met him in South Africa and we had a discussion, and again, it was, yeah, he wants to come, he's willing to come, right? But government has declined. So the invite, so the question is, are there mechanisms in place to sort of navigate around this issue where government then declines?
Yeah, that is a challenge, because in terms of visit, until the government approves, they will not really try to come. Otherwise, it will be difficult. But in such situation, just like George said, we don't lose hope. It's just a matter of But the special rapporteur, has he sent communication to the government on that, on those issues? So that is then other platform then one can use again is all this treaty body reporting and even this issue of UPR, because one of the recommendations again that I'm giving to the government again is to maybe to be open to such visit. Yeah, because the issue of the concept of sovereignty is so strong in the international human rights law that sometimes you think is a stumbling block. But for human rights, as far as human rights is concerned, we don't lose hope. We just keep pushing through some of these mechanisms. Hopefully, at least now you have a new government. Things may change. All right, so let's proceed. I think this one won't take time. So this is United Nations anti-racism mechanisms. So when we talk about the United Nations anti-racism mechanism, we're talking about the structures put in place at the global level to address the scourge of racism, racial discrimination, xenophobia, and related intolerance. And you can see that the issue of racism and fight for racism is so important. It's so important to United Nations that they establish 8 different mechanisms. So they establish 8 different mechanisms to fight racism, racial discrimination, xenophobia, and other related intolerance. I'm not aware of any other challenge that United Nations has this number of mechanisms. So one of the mechanisms, you see, the working group of experts or people of African descent. We have the Permanent Forum of people of African descent. They have the expert mechanism on racial justice and equality in law enforcement. You have the Committee on the Elimination of Racial Discrimination, which is SAD, that we're mentioning. You have the Special Rapporteur of Contemporary Forms of Racism. We have the Intergovernmental Working Group on the effective implementation of the DDPA, the Durban Declaration and Program of Action. We have the group of independent eminent experts on implementation of the Durban Declaration and Program of Action. And then the ad hoc committee on the elaboration of complementary standards to ISAD. So, who among you who is familiar with the DDPA? Who is familiar with Durban Declaration and Program of Action? Durban Declaration and Program of Action. You are not familiar with it. So as long as fighting racism is concerned, DDPA is a very important policy document. So that's why we just look at what that DDPA is all about. So the World Conference Against Racism held in Durban, South Africa in 2001 aimed to address racism, racial discrimination, xenophobia, and related intolerance on a global scale. So the World Conference held in 2001, and the outcome of the World Conference Against Racism is that document that we call Durban Declaration and Program of Action. So it is the United Nations blueprint to combat racism, racial discrimination, xenophobia, related intolerance globally. So although the DPPA is a political commitment that is not legally binding, it embodies the firm commitment of the international community and has a strong moral value that serves as a basis for advocacy effort worldwide. So it is a victim-centered document that emphasizes the plight of victims of racism, racial discrimination, xenophobia, and related intolerance. It reaffirms that states have the duty to protect and promote the human rights of all victims. So so just look at briefly those mechanisms. This one is the Committee on Elimination of Racial Discrimination. Of course, during my last presentation, I keep mentioning SAD. This is like I said, this is a treaty body that monitors implementation of SAD. Essentially, that the body that the states report and they review They examine each state report and addresses its concern and recommendation to the state party in form of concluding observations. Then talk about the special rapporteur. The special rapporteur of contemporary forms of racism. So this is an independent expert that that monitors issue of racism globally. And like we said about the special rapporteur on indigenous groups, issues of racism can also be communicated to the special rapporteur, and he conducts state visits, undertake fast-funding mission to countries, depending on the one that has consent, safety individual communication, and also submit reports to Human Rights Council and the General Assembly. So we have the working group of experts of people of African descent. This is also one of the mechanisms that, which was also specifically mentioned in the Durban Declaration and Program of Action. It's composed of 5 independent experts, and it has mandate to study the problem of racial discrimination faced by people of African descent and make proposals to eliminate it. It accepts the individual communication, it holds in-person sessions, also give annual report and country visit. So we have the expert mechanism to advance racial justice and equality law in law enforcement. So we also have the permanent forum of people of African descent. These are all important mechanisms for those of you that work on the issue of non-discrimination. These are the mechanisms that you can rely on. So we have the Intergovernmental Working Group on the effective implementation of the Durban Declaration and Program of Action. So we have the group of independent eminent experts on the implementation of the DDPA. So we have the ad hoc committee on the elaboration of complementary standards. Then we have the second international decade for people of Africa. I think somebody mentioned this. We have also a fellowship program for people of African descent. Then as a civil society organization, how do you get involved? Because all these mechanisms, all of them normally put out call for input because they have their annual reports and they put out call for input. So as civil society organizations, you can contribute to those call to input and put in any challenge you feel that you observe within your domain. You can also send shadow report to SAD for country visit. If they're coming to, anyone that's coming to South Africa, it's an opportunity for you to also meet with them and follow up. There are sections of the working group, there are individual communication. You can, unlike treaty bodies, you don't need the consent of your state to communicate to some of these working groups, some of these groups we mentioned earlier. Yeah, essentially, I think this is all my presentation. Thank you. Any questions from me? Any question? Yeah. Where is the mic?
I'm just curious. Your offices are based in Pretoria, in South Africa. The current human rights situation in South Africa, it's touching a lot on what you are presenting here. How easy are you finding it to assist the government or institutions within South Africa to address the current human rights violation situation, especially with regards to foreigners?
Yeah, every country has their peculiar challenge. Like the challenge in South Africa is different from the one in Namibia and some other. Of course, we also provide the same support we provide to government, and also ensure that they do what they're supposed to do. For instance, I'll just give you example. There are a group of people that go to, they call them Doodla movement. They go to hospitals and they will chasing people away. They will chase people away from hospitals that are foreigners. such things are condemnable. But the good thing is that the government is not in support of it, because we engage with government. In fact, the government even get some of them arrested. So, of course, despite the challenge, we provide the support we're supposed to provide, and of course, government is also responding the level they can. But like we say, human rights work is not something you do and you expect results immediately. You just keep pushing, keep advocating, and at least, as far as we are concerned, we are recording progress despite the challenge. Another question? I see that the government is here. All right. Thank you very much.
All right. No, thank you so much. Francis, thank you so much for the presentation. And I just want to let you know that this is one of the conventions. This is one of the treaties that so many countries in the sub-region are lagging behind in terms of reporting. And we have also noted that civil society organizations are not really engaging with this instrument. So we are happy that Francis was able to take us through the substantive content. So Francis, thank you so much. Colleagues, as I mentioned and as I promised, and I was very hopeful that we are going to have the government. We have with us here Mr. Lennon Limbo, who is the chief of Legal Services in the Ministry of Justice and Labor Relations. He has been very, very instrumental in terms of advancing the work of the government, in terms of engaging with the human rights mechanisms. And I come a long way with him. That's why I was very, very optimistic that he is going to come. And I'm happy that he has made it. I think if I look at the progress that the government has made, when I first came to this country in 2015, all the reports of the government were overdue for submission. All of them were overdue. But if you look at Namibia at the moment, Namibia is one of the few countries in the sub-region that at the moment don't have overdue reports to the treaty bodies, thanks to the work of the Minister of Justice and thanks to Mr. Limbo for his proactiveness. So I'm glad that he has come here to take us through the roadmap of the UPR. And Mr. Limbo, thank you so much for coming. The floor is yours. Thank you so much.
Good afternoon. As indicated, my name is Simata Lennon Limbo. I work for the Ministry of Justice and Labor Relations. As my colleague, Mr. Fokwa, has indicated, we know each other for a long way. It's been many years, he gave us our training back then, and as he has indicated, we had quite a backlog of reports. And as we speak, there are only 2 reports due, and the other one is not a UN system human rights report, is an African Commission report. And it's due deliberately because we want to get the report to be drafted accordingly, according to the guidelines and rules. So this particular one we are not behind in terms of submission. This will be our 4th time submitting. However, we have submitted the first cycle, midterm review of the first cycle, and second cycle, same thing, midterm review of the second cycle, as well as the third cycle. Unfortunately, we did not submit due to pressing times. As you know, this year we have elections in November, so it will be quite tricky and hectic. And besides that, we are not yet sure as to what date, but we were banking on on February, the submission date. But it's 26 January, and we are still of the opinion that we can make it. Yeah. So basically, the directorate that I had is responsible for drafting human rights reports for the country. And at the same time, we are also the secretariat to the Interministerial Committee on Human Rights and Humanitarian Law. But apart from that, we do other things. Like, for instance, we draft extradition requests to and assist with requests from other countries to Namibia. So we tend to be busy in that front when there are crimes that involves cross-border matters. We also deal with mutual legal assistance in criminal matters, as well as reciprocal service of civil processes, reciprocal enforcement of foreign civil judgments, as well as reciprocal enforcement of foreign maintenance orders. So I'm here to present to you a roadmap which we have prepared for the fourth cycle of the UPR National Report. This year, we have held 2 engagements on UPR. The first engagement took place in August. That's why you see on the first date, it says convene stakeholders meeting. There was a meeting that was conducted, and that meeting was conducted with the assistance or help of the Commonwealth Secretariat, the Human Rights Desk. So after that, we had given ourselves a deadline of 30 August to submit response and inputs to the draft UPR report by way of a Google document, shared document. So what happened was all the people that participated in that particular engagement were able to see live changes to the document as colleagues were giving input and whatnot. And that was done, and then it was then shared on time. So at the moment, we are at point number 5, there or thereabout, in between. So before the end of August, we thought it would also be wise to request for technical assistance from the Office of the High Commissioner for Human Rights, the Pretoria office. And they heeded to our request and call. Thank you very much. And here we are. The past 2 days in October, meaning the 21st and the 22nd of October, which are not indicated here on, we held the workshop, or rather a meeting, workshop, and technical assistance was provided to us, and we completed that exercise. So that's why I'm saying where we are now is towards the end of October. Yesterday we gave ourselves a task and deadline of Friday, this coming Friday, meaning tomorrow, for those that were present, the stakeholders that we were with, to submit by then, Friday, comments or outstanding information which we had requested or which we had identified not to be in the report. So that part is missing at the moment on this roadmap. I think it suffices to say that the feedback, this date, we are ahead of it. If colleagues will submit by tomorrow, we should be ahead of the 30th of October. So what my colleagues and I are thinking of doing at the moment is to ensure that by the 30th of October, we should have a clean report, a very clean report. And we were hoping that after that, our plan is to hold an IMC meeting. The IMC meeting, another IMC meeting, and the purpose of which will be to discuss the draft that is as a result of the past 2 days' deliberations and amendments. So, and then thereafter, obviously, because by then will be in November, we hope to share the draft to the Commonwealth for review. And in doing so, we will then move up to perhaps by the 19th of November. But in between there are many things that we'll also be doing. We'll be sharing the draft with our bosses for them to go through, and also still receiving input from our other colleagues in terms of drafting, responding to the queries, and making sure that the recommendations are adequately addressed. At the moment, I'm still waiting for information from the Secretariat of Cabinet of Namibia to find out exactly what is the last day of Cabinet in Namibia for the year. And we are hoping that before the end of November, that we can at least submit it to Cabinet, and with the understanding that if we submit it to Cabinet, somewhere in between there, we can call for a meeting for the CSOs and the parliamentary committee, and maybe UNAM, other educational institutions, and other associations, maybe ALAN, I think Association of Local Authorities, look at associations of traditional leaders. Yeah, those are some of the organizations that we are looking at. But at the moment, I cannot commit until I know exactly what is the last day of Cabinet deliberations. As you know, Cabinet deliberates twice. There is the first Cabinet, the deliberative Cabinet, and then the decision-making Cabinet. And you have to give your documents, I think, a week or so in advance, so that they can take it on board and discuss. It's a bit tricky this year again because of the elections. You are aware we have elections in November, I think. Yeah, so that is where we are thinking that hopefully, even if Cabinet, let's say, goes through the document, usually Cabinet would permit, if they are not happy with certain things in the report, they would permit the Minister of Justice to carry the process forward to avoid delaying submission thereof, unless if it is something that is so critical that the report must be returned to them when it's finalized. Okay, so we still have some time to have a meeting. What we are also doing, and we find comfort in this, is that even if whenever we meet, even if we meet with the CSOs, we will give them the draft as to where we are at that particular time. So at the moment we have draft number 3, which is what we ended with yesterday. So once we share the draft with have this consultation, we will obviously consider what the flow suggests and so forth. Other than that, to take you further, once we are done with submission to Cabinet, obviously the most important part is to ensure that it is submitted before 26 January 2026. And then that is the red flag for us. We need to submit it before then. This period is a bit tricky, as you all know. If you for those who are in Namibia, I think it's the same even in Pretoria, South Africa, where you're from. That usually that period, the government and private institutions, they all shut down. We all go home. Windhoek is empty. Yeah, so we want to make sure that it's ready before the festive season starts. And then by March, we hope to have finalized the delegation, a Namibian delegation to the UPR review. And hopefully, I think my colleagues indicated that we can have a virtual mock session with the Commonwealth. Don't know whether you want to say something about that.
Yes. Just to add that, yes, the Commonwealth is always willing to support states to do a mock session. The mock session is because there are some officials that maybe this is their first time to take part in the UPR process. So they can also support states to organize like a mock session of the review. We also do that as well, and we also work closely with the Commonwealth so that it helps. Sometimes it is done online. Sometimes it is done at the level of Geneva. When a delegation is in Geneva, then they are going to be taken to the Commonwealth Secretariat, and then they are going to be briefed as well. By then, the advanced questions and also advanced recommendations are also going to be available online, and then the officials can also have access to them so that they can also prepare for the review. So I'm glad that you have this roadmap in place. Thank you.
Thank you, Mr. Fokwa. So basically, once that is done, then we are going to prepare a national statement that will be read by the head of delegation to the UPR session. I think you have seen pictures of how the setup in the Human Rights Council looks like. We'll be sitting up there, or whomever is going, if it's not done online, if there is no other corona type of outbreak. Yeah. So then there's a proposal to orientate us by the Commonwealth in Geneva. We are always amenable to that, but as you know, Namibia has a permanent mission to the United Nations in Geneva. Yeah, so basically that's that. On the 4th of May, then will be reviewed. I think he has also taken you through how the review takes place. We will have our time, and then countries will ask questions, have the right of reply, and then eventually there will be a vote on whether to adopt the report of Namibia, and then countries will agree or not. Mostly they agree, then they'll come to us and then shake our hands and say, well done, blah, blah, we are done, thank you. And then we must come back home again and share the outcome of the UPR with yourself, if I'm not mistaken, somewhere in 2016. Roadmap, in short. Thank you so much.
Yeah, thank you so much. And I just want to also mention that we have also discussed with the government that after the review, we are going to engage with them. Then they are going to also think about the way forward towards implementation. So I think that is going to come. That is going to come after the review. Colleagues, any questions before we release Mr. Limbo? Mr. Limbo, there are some questions for you, please.
Thank you. Hello. Are the reports available online as well? Thank you.
Thank you. Yes, I just want to mention that once a report has been put into a UN format, it's going to be online. The same link where I showed you, you can find all the reports there.
Thank you. Wanted to know, what is your sense of civil society participation in this last round of sessions that you had, especially people from the regions and their level of engagement? Also, if you mention about the Namibian delegation, who is part of this Namibian delegation, and with particular interest with civil society being part of such a delegation. Thanks.
Do you want to take the mic?
Good afternoon. My name is Shaligan Peterson. I'm from the NMT Media Foundation and a freelance journalist. Maybe I missed it. You spoke about the stakeholders you engage. Maybe if you can just tell us who these stakeholders are. You also to just perhaps a comment on your submission to cabinet. Cabinet agenda is usually discussed weeks before, if not months before. Cabinet usually ends in the beginning of December. Do you really think you'll meet that deadline? From what I know, even the submission, unless it's an emergency and government considers it an emergency, I highly doubt you're going to make the timeline and that submission. Yeah, just a comment. Thank you.
So Limbo, do you want to also take the third one? or you want to just, you'll forget? Yeah, please go ahead with this too.
All right, thank you very much. The delegation to Geneva for this UPR is usually from a government perspective, one of the government, as it were. So government only pays for its delegates. Usually as we take, there's a head of delegation, and obviously the representative of the state in Geneva is the ambassador who's resident in Geneva. And then we take from government key members of the IMC, meaning in this case you would get colleagues from other ministries to accompany the head of delegation, those that are able to answer questions that are pertinent in the report. Ideally, it should be people who were involved from those organizations, such as Ministry of Health, Gender and Education, and I think Ministry of Home Affairs as well, because of the cross-cutting issues relating to police, immigration, as well as correctional services. Yes. I'm positively not doubtful. I'm not doubtful at all. It has never happened that the minister takes a report to cabinet and they say, no, back burner next year. I think my experience is that we tend to be very, how do you say it, without being misquoted? You're a journalist, so you write about it. Joking. Yeah, so we tend to take these issues of human rights very seriously. I would be very surprised if the ministers or cabinet rejects the report. Yes. What
Yes.
is there about the stakeholders?
There was a question about
That
the
were involved
stakeholders.
now. We had UNAM, there were one or two NGOs, but it was not really full participation because of the fact that they got involved at a very late stage, like on the last day. Yeah, I can get their names. I didn't read the attendance list as I came here, so I can't recall offhand who they were. Yeah, but it also suffices to say sometimes we have invited people like Ms. Dempers to the IMC meetings. They attend those meetings, some of our meetings. Yes.
All right.
Huh?
Thank you.
One. Okay.
Thank you. You mentioned now that there were two NGOs involved. Question number one is, would there be another opportunity to then engage civil society again? Because I think we're dealing with a very pertinent issue when it comes to human rights. And yes, and representation matters, because civil society deals with on-the-ground issues in this country. And then also, how would we ensure, if there will be another consultation or convening, how would we ensure that it's inclusive, that the word actually gets out there, that civil society is actually involved, and you do not sit with 2 or 3 NGOs here, and you would rather have a room full, because and I know it will be in Windhoek, that's the unfortunate part, but at least a room full of civil society.
Thank you.
All right.
Let him take this one, then I'll take them.
I'm not so sure whether we are going to have a room full of civil society, because we have been inviting the umbrella body, NANGOV, so to speak. And at some point when we were in Geneva, we were defending, or rather having a dialogue with the ICCPR committee. I met some people from Namibia at that particular review, and they had something to say about NGOs, who's representative and who's not. So that bit is a bit tricky for the government to say everybody must come. And now we probably have to do that homework on our part from next week to find out who should we invite to this year's CSO meeting regarding UPR. And I think once we establish that, we will be able to send out to those that are identified. Not identified in a sense of preference, no, but those that are known to us or made known to us. Thank you.
All right. Yes.
Good afternoon. Name is Rivaldo Korirap. I just wanted to add a point there. For instance, there is a say, building or developing without transparency. For instance, you come to an issue within the community and you want to solve that issue, but you can't solve the issue without consulting the community. So building something without consultation is not transparent. So what I'm trying to say is, since we had this session today, there has been a lot of conversation whereby the government is lacking, yeah? For instance, there has been a lot of suicide rates, housing problem, but if you do only invite 2 or 3 civil society organizations, that is not considerate, because information that is needed, that is on the ground, won't able to come to you. So I think you should create a better way to approach the civil societies to bring their information on the table, because as a civil society organization, we have a lot of issues concerning the government and its accountability towards our economy and development and consistency.
Thank you.
Is that a statement? It's a statement, yeah.
All right. Ben, thanks.
Thank you so much. My name is Ben Schernick, Director from the Nutrition and Food Security Alliance, but also part of NAMNET. And I'm glad you mentioned Nangov. I can't speak for Nangov, but with Nangov, there has been a bit of uncertainty around it. And as you will see in NDP 6, for instance, pages 29 and 30, there's a small chapter on civil society. And also this event was kind of co-organized by Civic and NAMNET. And we are in the process of forming an MOU, because Civic is an excellent communication platform and database of different individual NGOs, whereby NAMNET is a newly formed umbrella body of umbrella bodies. So that was formed last year. And the idea is to really be representative of different sectoral umbrella bodies. And I think these would be the 2 key umbrella bodies in the moment to speak with. I can't speak, as I said, of Nangov, so I don't want to exclude or anything. So Nangov needs to speak for itself at this point. But these are the 2 bodies that we also engage with NPC, and that is therefore reflected in NDP 6. So I think going through Civic and then through Civic engaging both NAMNET and Civic would definitely be enabling that access to the broadest range of civil society, I think, that is possible in the moment. Colleagues from Civic and NAMNET, if there's anything to add to that, please come on in there.
All right, colleagues, there's a question here. I'll pass it over. I just want to mention, let's not deviate so much from this. These are very important points. And I think this builds on the point that I mentioned to you, that as civil society organizations, you have to put yourself together. The government is dealing with so many things. I don't think the government will be much more focused about the nuances of everything that is happening within civil society organizations. So I think it's for you to really look at it and put your house in order, organize yourself, so that you can also engage constructively and in a very constructive way with the government. So I think it just builds on the points that we had mentioned. So I just want to take the last question or the last comment, so that we don't keep Mr. Limbo for too long.
Good afternoon, ladies and gentlemen. My name is Samuel, representing a Deaf Empowerment Association. So I have been following the presentation, and I heard that there is a list of stakeholders that you are working with. So I just would like to ask if organizations of people with disabilities are also part of your stakeholders list, or are we excluded, or because I never heard of any of your meetings. Thank you.
Over to you.
Right, thank you very much for the questions. Yes, with regards to the civic organizations that are supposed to be invited, I would request that maybe before I leave the room, that you give me the contact addresses and numbers of email address, as the case may be, of those organizations you've mentioned, Civic, Namib, Namnet. Yes, maybe those two. We already have contact with Nangov. I don't know now how, and I think Mr. Fokwa has indicated that that's up to yourselves as CSOs to figure out how you organize yourselves. With regards to the question on whether we exclude or we include the organization on, is it disability? People with disability. We do not discriminate. And when we invite CSOs, they are also included. They are most welcome to come and attend our meetings. The Ministry of Gender has, I think, a component or a directorate on disability. There's also the Disability Council, which are part of government. So therefore, they can be catered into that. Yeah, so that's my response on that. All right. All right, thank you very much. It was really an interesting discussion.
Of course. All right, we'll be closing off with a few closing remarks shortly, if you can give us a moment. Thank you very much for your time. All right, colleagues, so I think that we've had a busy day, a fruitful day. Thank you for your attention and your contributions. I think if there are no further closing remarks from the floor, I would like to extend my heartfelt thanks for your attention. It's been a very long day. And I think we all learned a lot. I feel that I did. And I just want to give you my thanks. I also really want to thank Mr. Fokwa for a very valuable presentation shared with us all. I have that presentation, and I'll also be sharing it with all of you, as well as along with the summary, so that we can take all this information forward. So thank you very much, Mr. Fokwa. Also, Mr. Ikurario, thank you so much for that information on racial discrimination. I think that was very important for us to learn so much of that information I did not know, and thank you for your presentation. I'll also be summarizing that for all of us to be able to take that information forward. Yeah, it was a pleasure to be able to invite you all here. I will also be sharing a recording of today's event, so if there are any of our colleagues who are sad that they were not able to make it here today, I will be sharing the recording widely on all our networks, and I hand it over to you to also please feel free to share that with anyone who requests it from you. What else is there to say? Thank you very much. It was a pleasure to be able to bring you all together here. Please reach out. I think there was a lot of call for greater cohesion and coordination amongst us. And I stand ready in front of you to take up that beacon. So reach out to us in ways that you need information from us, you need coordination from us. We're ready to serve you in that capacity. Thank you for coming, and thank you again, Jean. Thank you so much for organizing all of this. Mr. Ikuragwa, thank you so much for being here. Thank you for everything we were able to learn from you. I think I'll hand over to you for some last closing remarks.
Well, I don't have so much. I don't want to keep you here for too long. Just have to thank all of you. I think it would have been a missed opportunity for us to engage with the government without engaging with civil society. And I think so much came out from this group, which we are very, very happy. And we just want to let you know that all the comments, all the inputs, all the suggestions, we have taken them into consideration. And we are going to work on them. When you have a consultation like this, it is a means to an end. It's not an end to itself. So we will continue to engage with you. On that note, just want to thank Civic Plus 264 for your support, for coordinating the process. I also want to thank all of you. I mean, you have been an amazing group, and it has been nice engaging with you. I also want to extend a huge thanks to my colleague, Francis, for his support in the planning of this mission, and for us to be able to deliver this consultation together. And I also want to thank the Office of the UN Resident Coordinator for her support in this process. So I wish you all a very, very successful work as you continue to work on this journey. As I mentioned to you before, we are experiencing so much pushback on human rights. Let's not relent our effort as human rights defenders, and we will continue to work to ensure that we integrate human rights principles, norms, and practices into all aspects of life. And we know that it is a difficult journey, but let's not give up. And thank you so much for all your support. And we will just have to close because I don't think we can take another. It's a quick one. All right. So thank you so much, everyone. Thank you so much. Thank you.
Good afternoon. Sorry that we are crossing now, and I just forgot something. So I just want to inform each and everyone that we have an app for sign language. So if you can just take maybe a leaflet or something during your free time, you can just go through your phone and learn something or learn a word in sign language. Thank you.
Thank you. Please, it's important for you to have this. I think one thing that you should know is that so many countries now are making sign language as a national language. Yeah. South Africa has already done that. Please. Please. Can just pass. Oh, sorry. I'll take this one. So, colleagues, we are going to send all the presentations to Civic Plus 264, and then they'll disseminate all the presentations to you. My card. All right.
Yes. Guy was saying he wants this before you. Yeah. So can you? It's fine. I'll just scan it. Thank you so much.
May I have a photograph of the two? Just take a photo.
And then we can take this. No, I'll take the picture and then.
Okay. And then you can join. Thank you,
Yeah.
Kevin. Appreciate it. I'll ask. All right. Shall we just stand here? All right. Thank you so much, Kevin. Thank you so much.
Do you have a business card?
Yes, come.
And if you need to send anyone something. Have a lovely evening. Thank you very much. It was lovely to meet you. I was really looking forward to it.
See you. It's definitely always. If you need any option.
Yeah, it was valuable. I learned so much.
Yeah.
So, okay. Hello. How are you doing?
Good. So,
I'm good. I can't complain. Ah, good, my birthday. Is that Shiryan melodic voice? I cannot complain. You're not allowed to. It's not easy. Yeah.
it's really, really pushing. Maria? Do you guys have something? You guys have something? You have something in here? Yeah. Where is that guy? No, no, no. I'm saying the room. Yeah. Don't worry.
Now we can do it with yours. Would you like to join us, please? Yes.
Let me just put this down.